of the votes for December 4th, 2023. Roll call.
Poston.
Roll call.
Poston.
Here.
Rawson.
Here.
Beck.
Here.
Dixon. Here. Maxwell.
Here.
All right, before we start into this meeting, I want to read this statement and welcome everybody here for this meeting. As Board of Supervisors understand, there are supporters for each candidate present who would like to comment to the Board of Supervisors regarding this election and the recount process. Understand that each supervisor has received numerous emails and calls from both candidate supporters and have been kept advised throughout the recount process. It is unfortunate that this recount process has been marred with allegations that the state of Iowa laws have been not followed and tossing the school district and the county into unwarranted controversy through no fault of our own. As a result, the question at hand is, what legal authority does the Board of Supervisors have regarding the recount report? As with any other canvassing meeting, there will not be any public comment period so that we can hear from our county attorney and our auditor regarding these allegations of violations of the Iowa voting law and the options the Board of Supervisors may consider. So I will ask, hopefully everybody here will receive a proper decorum. I can't speak, thank you, but you know what I mean. Decorum, thank you. And we'll proceed now with the opening of the questions for both the auditor and the attorney. So I will lead off with the first question that I have, and this would be for the attorneys to step forward. Yeah, just bring your chairs if you want to. And if you would go ahead and identify yourself so everyone knows.
Yes, Christina Lyon, Assistant Scott County Attorney.
All right, the first question I do have for this is, what is the authority the Board of Supervisors have regarding canvassing of votes?
Yes, after consultation with the Secretary of State, it is our understanding that the Board of Supervisors, if two of the recount board have signed the report, which is consisted of 2 pages, and it is clear what the intent is, that the Board of Supervisors shall accept that report and take the next steps in the process, which we believe, if it's resulted in a tie, would then have the Board of Supervisors drawing for who would be the winner.
I guess in your interpretation of shall, there's very little room that word provides the Board of Supervisors regarding latitude on this accepting or rejecting of the canvas.
That is correct.
Okay, Supervisor Maxwell?
So to put it into kind of a layman's terms, we see the piece of paper, it's presented for us, we mark received on it, and we push it on to the next level, so to speak.
Are you talking about you or the auditor's office?
I'm talking about the Board of Supervisors gets the canvas, and it's not for us to judge whether it is lawfully correct or anything in that matter. We're just a body that basically says received and moved on.
Correct. Once you receive it, as long as it has at least 2 out of the 3 signatures on it, and as long as you can discern what the intent was of those at least two people, then you are to receive it and take the next steps.
And as I read the code, it is just a matter of the only thing we would do is if we saw a clear mathematical error or an arithmetic error that we would say, and everybody in the party agrees that, yes, this was an error, then we would correct it. But that's really all the latitude we have. Is that correct?
Correct. Potentially for a clerical error, which would allow for misspellings, yes, a math error, something like that. Not anything about anybody's intent or what we believe may or may not have been done wrong.
Or whether it's legal or anything like that.
Correct.
Okay.
It is just to accept those results. other than I believe the board may have the opportunity, if they wanted to ask for clarifying information on it if it was deemed necessary once that report was received.
Okay, thank you.
Let me ask this question, then I'll get with super caution. When you say clarify, that means basically you could not legibly read it. There would be something there that obviously wasn't clear on what the final count was. Is that what clarification would mean?
Yes, if the Board of Supervisors couldn't, again, discern the meaning or the intent of what the at least two signatures on that report were, then the Board of Supervisors could gather further information from the recount board to make sure they understood the meaning of the report and the result.
And have you seen the report?
I have.
And in your opinion, it's clear and legible?
I believe the report paired with emails from two of the recount members shows that it is clear that the intent of those two members was to declare a tie.
Okay, thank you. Supervisor Poshin?
Yeah, what's the consequences if the board votes no?
Under the code, I don't believe that that's an option.
Then why are we here? It's pointless. Why do we, if we have to vote yes, then I don't understand. But
I suppose it's because
so what you're saying is if I vote no, you're going to put me in jail or something? What's the state of Iowa going to do to me?
our role in the election contests and recounts is not to be the fact finders. We're to advise everybody on what the code says. Unfortunately, the code doesn't provide necessarily for what the consequences may be for that. The code provides the shall language that it has to be accepted. Now, what other remedies anyone may have in this situation would be open to, which we'll get into, a potential contest, or if anybody wanted to bring anything up with the district court and file some type of lawsuit.
I'll just add from the conversations I've had with many people this afternoon, basically a shall is will. And if it's not voted to accept, you're breaking the law. So that's the interpretation I have received. So other comments? Supervisor Dixon?
Yes, Ms. Lyons, so we're looking at Iowa Code Section 50.24 subsection 3, correct? Is that what you're relying on? Where it says the board shall certify an election canvass summary report prepared by the commissioner?
Correct.
So commissioner is the auditor?
Correct.
And then this does presume that there is an election canvass summary report that's being submitted for us to certify, correct? I know that seems kind of obvious, but it does presume, just by looking at it, the board shall certify an election canvass summary report prepared by the commissioner.
Correct. And I just want to clarify under 50.48 subsection 5, that's if the recount board's report is that the abstracts prepared pursuant to the county board's canvass were incorrect as to the number of votes cast for the candidates for the officer nomination in question in that county or district, the commissioner shall at once so notify the board. The county board shall reconvene within 3 days after being so notified and shall correct its previous pleadings.
So are we looking at both statutes? Sort of in hybrid?
Yeah, you have to consult multiple, Iowa and administrative codes for the election
That's kind of
provisions.
But either way, we're looking at the document that we're looking at is this election canvass summary report, or I guess it would be the findings of the recount.
Correct.
Okay.
As my conversations this afternoon, it's my understanding that the 50.24 reflects the original canvas and that 50.48 is directed towards the canvas of the recount. So the conditions under which 50.24 would not really be the code that would be applicable to this particular recount discussion.
But what we're looking at is a document.
Correct.
Yes.
I'm asking, that's all right. I'm actually asking Ms. Ryan. So that's all right. So we're looking at a document. That's what we're talking about today in terms of what we shall or shall not, that we shall accept would be the document, correct?
Correct.
And then, Okay, that's all I have for now. Thank you.
Thank you. Other questions regarding this? Yeah. Okay, Supervisor Rawson.
I actually have a question about the Canvas committee and how that was structured and how the ballots were counted and notated, but I think that might be better suited for the auditor, perhaps, as far as the legality of it.
If you don't mind, we'll have a report. The auditor has a report to read, but while we have the attorney here, I prefer to ask a few more questions. And I'm not sure whether she's able to answer these or not, but we'll give it a shot. And could you get your microphone? Thank you. If there's any more questions regarding the authority that the Board of Supervisors has, if there's any other questions, we can go back if we need to. What is the state laws regarding write-in votes and filling the target?
In this election, you have to follow whatever rules were followed on the original election day on November 7th. There were optical scanners used, and therefore the rules for optical scanned votes must be followed. In conjunction with that, there was a write-in candidate in this election, and so you also have to look to the rules for write-in candidates and what can be counted for votes. On optical scan votes for write-in candidates, there's a requirement that not only do you have to write a name on the line of the write-in candidate, but there must also be some mark to the left of the name filled in. Otherwise, that marking will not be picked up on the optical scanner. Now, these rules must be followed even if the recount board would elect to hand count the votes. So it may not make a lot of common sense sometimes, but what that results in is if you are hand counting those votes, you still have to follow the rules for optical scan votes, meaning that if a write-in vote would require the name of the candidate, also a mark in the oval.
Okay, other questions?
There are also a lot of other rules for what markings might be considered or what you have to do for votes to count, but that's the one specific to the write-in candidate.
So your opinion is that if the target is not filled in, even though a name is next to it, that is not a valid vote, either during a regular election process or during a recount.
That's made very clear by the code.
Yeah, okay. Supervisor Maxwell?
But it's not our job to weigh in on that matter.
Correct.
Thank you. And I guess the next question, I don't know if you can answer. I guess it would require somebody on the recount board to answer, but were there votes counted during the recount process where the target was not properly filled in?
I was not there physically to witness all of the ballots that were counted. Per notation on the tally sheets, it was brought to our attention that it's believed that yes, votes may have been. But again, it was not our role in this recount process to determine whether or not those votes should or should not have been counted as it relates to the recanvass today. So I personally was not there to witness it. All I have is information coming from different parties and sources to inform that may be the case.
I think I do recall. Sorry. I'm sorry. I understand, at least I recall, I believe I recall that there was an email that came through that one of the recount board members indicated that they did count votes where the target was not was improperly marked, either with an X or not marked at all, which in either case, and for both candidates, my understanding, those were counted. And I don't know if any other board members remember, but I believe that was the case.
I also remember reading that in one of the emails.
Okay, Supervisor Dixon?
Yes, just to clarify, the packet that Ms. Tompkins gave us, excuse me, delivered to this board on Friday included 10 pages. Page 10 was an email from one of the recount members wherein he stated specifically that, quote, Ms. Tompkins, I read the emails on this matter. We counted by hand over 20 boxes of ballots. Some of the write-in votes did not have the ovals filled in, but had Ms. Ramirez, that's the typo, name clearly written on the line. And then it goes on, it says, all of the above were counted. And then on page 9 of the, again, I'm relying on a record that Ms. Tompkins gave to the board. So I just want to clarify, I'm not going outside the parameters of what the board's been given. Then on page 9, another one of the board members, or excuse me, one of the recount members said, quote, I am in agreement with the detail provided by Honorable Mark Smith, close quote. So there's no dispute that in the record that the Board of Supervisors has been given, that law was not followed.
Okay. And, you know, my purpose of this line of questioning, just to make sure that the record is clear, because there's been so many emails we've got and calls we've got where the information just is not accurate. And I want to make sure everybody in this room and anybody who's taken notes here understands what the true information was. And hence, the next question I have, and it's for either the auditor or the attorney, what is the law regarding the recount report? Who keeps it, until when, and when is it turned in? So I'll let whoever wants to choose to answer that.
The report is not due till today, and they have until the end of the day today, and that goes up until midnight. So the law is very vague as far as who has that, but it is not due until today. So any of the board members could have it. It is their responsibility to put that together. And again, it's not due until the end of the day.
Okay, so just to clarify, any of the board members could keep the report until the time at which it's due to be turned in, which
Yes.
is midnight tonight. Okay, but you have received the report, obviously, since we're here.
Yes.
Okay. All right, Supervisor Dixon.
So to clarify, in the perfect world, could the recount board reconvene and reconfigure their numbers, and we could meet at 11:30, 11:45 tonight?
The report just has to be turned in today by midnight, and then the recanvass, we have 3 days to do that. So
Okay,
yes.
so that could be done.
Correct.
Thank you.
But once again, that's not our choice. That's for the recount board's choice to do that. And we're here to canvass the votes, we can't tell them what to do. Neither can the auditor.
And to clarify, I wasn't asking about direction. I was asking about whether that could be done. And like I said, in a perfect world.
Yeah. And since I don't know all the recount members, I don't know if even any of them are here. Okay, Cindy? Okay. And I think that Cindy has reached out to the other board members, and there has not been any response to accept the offer to get back together again to do a recount in accordance with the laws of the state of Iowa. So I guess really the last the question I have is for our attorney, and then, would you like to read your statement this time before I go? Sure.
Yes, thank you. The city school election was held on Tuesday, November 7th, 2023 in Scott County, with the votes tallied via optical scan per Iowa law. The official results for Pleasant Valley District 6 were Jamison Smith, 256, with 260 write-in votes. The write-in votes consisted of 250 for Tracy Rivera, with the other 10 votes for 7 other options. On November 17th, 2023, Tracy Rivera filed a request form for recount of votes, cast for office, and identified Arun Puletla as her designee to serve on the recount board. Jamison Smith was notified via my office, and he identified Cynthia Dirks as his designee to serve on the board. The third designee must be agreed upon via both parties. Unfortunately, there was not an agreement, and the chief judge, Henry Latham, assigned retired Judge Mark Smith as the third designee. Iowa law prohibits the auditor and the auditor's office from interfering in the recount process. The auditor's role is to maintain custody and security of the ballots. On Monday, November 27th, the recount began at the Scott County Warehouse at 10 a.m. to accommodate the board. Scott County Attorney Christina Lyon presented the process via Iowa law, Chapter 50.48, and answered questions from the board members. At that time, the board chose the hand count method. They finished on Monday around 4:30 and returned Tuesday morning at 9. Around 11 a.m., Smith handed me a report, and Dierks took possession of the report and continued a discussion with Smith. Some board members were asking questions and were advised County Attorney Ms. Lyon was on her way to respond. Before Ms. Lyon arrived, Smith and Palutla left the building. When Ms. Lyon arrived, Dierks continued to stay and ask her questions. The report was due by the end of the day, midnight, on Monday, December 4th, 2023. The report was never missing and was turned in early on Friday, December 1st, 2023. In reviewing the document, it is unclear as to the actual count. Through discussion with the SOS and Attorney's Office, I was advised to include emails from Palutla and Smith for supporting documentation of 2 board members supporting the 255 count that results in a tie. The Iowa SOS and the Scott County Attorney's Office have been consulted and provided guidance during this process. I appreciate the board's time and efforts for the recount process. At this time, please accept the results of the recanvass for Pleasant Valley District 6 as provided via Iowa law. Since there is a tie, a drawing must be held to determine the winner. Thank you.
My last question is very pointed. It's my understanding that if we do not canvass, it will violate Iowa state law. What is your recommendation for the board on how we should proceed?
These laws, as stated, do have the full force and effect of the law, meaning the language seems to be clear that to correctly follow these process, the board needs to accept this report.
Okay. Any other questions from the board? Supervisor Maxwell?
I'll tell you my struggle. My struggle is clearly, in my eyes, the recount board did not follow the law. And now we're supposed to follow the law, and it really gets, the waters get really muddy. And so I'm really torn as to how this should go.
Supervisor Rawson?
Yes, so, and I'll have to agree with Supervisor Maxwell. That's what I'm sitting here thinking. That's what I was thinking over the weekend was if we are held by the letter of the law, we have to pass the canvass of the votes, knowing that the canvass committee actually counted ballots that they should not have, that runs afoul of the law. That makes no sense to me. So clearly, I think that needs to be changed. Of course, here in the state of Iowa, that needs to be updated and changed. Because clearly that hasn't happened before. So 2 questions. One, so the ballots that were counted that weren't supposed to be counted, I just need some help understanding why were they counted? Do you have that answer? Why would you count ballots that are not countable by law? And if, since they did do that for both candidates, so it wasn't as if one candidate got a benefit and another one didn't, what's the ramifications for breaking that law, if any?
I'm just going to say that is a question for the recount board members because I certainly can't answer for them. So you would have to ask that group. And in regards to, I'm going to let you take the ramification.
Again, the laws that govern the recount have the full force and effect of the law. So theoretically, a ramification would be that the situation could be investigated, or like I stated earlier, that if somebody wanted to bring it to the attention of the district court, there's obviously civil remedies in play. Also to address that, I don't know that this has happened before locally, but the next step is that, and this was in a short brief that I have, is that there is the potential that one of the candidates or both of the candidates have the opportunity to contest whatever the result is tonight. And part of that contest procedure could include a recount.
And that contesting that you're referencing right now is that 3-day window that was mentioned previously?
No, that's the 20-day. That's just a different mechanism by which this was a recount that was requested, where there's also procedure set out in the law for an actual election contest. And the candidates will have the opportunity to follow that procedure after the vote tonight.
Okay. And just a clarification question. Initially, Ms. Tompkins, you mentioned Smith had 256 votes, but then the count came back from the committee at agreeing on 255. Is that correct? And what is that discrepancy?
Again, I'm sorry, but you'd have to ask the recount board.
Are we allowed to do that in this session, or? I'm not sure what the rules are as far as pulling up the recount board and
We're
I don't
here,
know.
we're here to determine whether we accept or not the
Okay.
canvas. And unfortunately, and Auditor Tompkins, maybe you can clarify, whatever happens here tonight, there's going to be one party leaving that's not happy and one party that is happy. And that's why the state allows the ability to contest whatever is determined here tonight. That contest is at the expense of the candidates. It's not at the expense of the county. So just so everybody understands that whatever decisions made here tonight is not going to be a cost borne by, the county. I was going to save this for later, but I think it's probably the opportune time to just read the statement that, I was really disappointed, so disappointed in this recount process that I was compelled to write this statement. If it were in the board's authority, I would recommend rejecting the recount and require another recount with a team that takes an oath to follow the laws of the state of Iowa. As we're being told here, the Board of Supervisors does not have the authority to reject the canvas in its current flawed condition. State code does not address what procedures are to be followed if the canvass of votes is rejected, but I'm sure it would expose the county to needless legal action, time that should be spent to the betterment of the citizens of Scott County and not a selected group. My preference is to have the individuals that broke the law be subjected to civil legal action and not the county. And, for this reason, I'm prepared to go forward on voting on the canvas this evening. So, Supervisor Dixon?
I just had, I guess, one more comment. So the law on which we're relying has the word shall, and it looks at this document. The packet that Auditor Tompkins gave us on Friday establishes on the face of the document that it's not within law. It's not within the law. And so for me, in my analysis, two things. First, there is, albeit antiquated, there is some case law by the Iowa Supreme Court that reads, for example, we are not prepared to say that the Board of Canvassers must canvass every return that is made to them. And then another one is that powers and proceedings of canvassers as to returns, canvassing boards and casting up the returns of an election act in a purely ministerial capacity and have no power to go beyond returns or reject those which are regular on their face or not shown to be spurious. So it's ministerial, but in some respects it's not absolute. And what I really struggle with is, and I look at like contract law, there's plenty of authority that illegal contracts are unenforceable. And I don't think that that's what the legislature intended when they wrote the statute. I don't know, but that's where I really struggle. Because the packet, when I'm not relying on hearsay, I'm relying on the 10 pages of documents that were given to the supervisors on Friday. And then I look at those in conjunction with Iowa Code Section 49.99. It doesn't comply with Iowa law on the face of it. I don't have to make any kind of interpretation. I look at the statement on the document and I look at the law. So that's where I struggle with. Thank you.
Others? Yes, Supervisor Maxwell.
So obviously we have some people that didn't follow Iowa law. And once we canvass, what happens next? Is there any kind of election fraud that would happen here that you'd say, hey, these people didn't do the right thing? This just reeks and smells of bad stuff.
At this point, when it comes to the recount, it's our office, the county attorney's office's job to advise as to the procedures that are here. Are there other mechanisms by which investigation can be had? Yes. That's not what we're here for today. But yes, obviously there are code sections and laws that govern election misconduct in Iowa.
that was more of a curiosity, not what my action is going to be or anything else. Go ahead.
I just wanted to comment to clarify for that. So thank you for asking. And that